I wish to call to order this meeting of the Health Occupations and Long-Term Care Subcommittee. I would like to advise everyone that there is a 2:00 meeting of the Insurance Subcommittee, and we're going to try and finish our work by then so that we will have a full debate, but I may, if we don't appear to be reaching a resolution on an issue, I will be carrying that debate over until the next time we meet, and we will be meeting another time regardless, and that will be an opportune time for bills to meet the crossover deadline. So, House Bill 68, Continuing Care, Retirement Communities, Governing Bodies, Grievances, and Entrance Fees. Lisa.
Okay, would it be okay with you if you take Lindsay's bills and then we go back to mine? Is that all right if we get her too? Sorry about that.
Fine, no problem. If that's the case, House Bill 806, Physician Assistance Revisions, Physician Assistant Modernization Act of 2024. Okay.
So this is the physician assistant bill that we've discussed for a couple of meetings now. There were some outstanding issues for consideration at the end of the last meeting. There are two changes from the last meeting in the latest version of the amendments that I circulated for the subcommittee. One is the study language at the end of the bill from the Board of Physicians. These are both consensus with the parties, and the other is adding administrative penalty language. This was also, I think, discussed at the last meeting in section 15309, which I unfortunately didn't bother to note the page number on. It's page 27 of the reprint. So that's new from last time. And like I said, those are consensus from the stakeholders.
And
do you want me to go into the items that were not consensus, or do you want to stop for a moment to discuss that?
Well, is there any discussion about those issues, on those two issues on which consensus has been reached since we last met? None. Fine. Good.
And just to clarify, there wasn't ever any disagreement about those points. They're just changes from last time that were raised since the last meeting. The points that there was disagreement.
Let's do them one at a time.
All right. So I'll say the first one was raised by MedChi, the language about interpreting diagnostic studies. And I'll let Steve talk about his concerns, I guess.
Mr. Wise, we are ready to hear from you.
Thank you, Mr. Chairman. I'm pleased to report, and obviously
the nursing home acquisition bill, believe it or not. I think
Lisa, silence yourself. Okay.
I think that's Tracy DeShield.
Yeah, it's Mr.
Sorry, whoever, please. Okay. Steve.
So I was about to say that Miss Elliott and I spoke this morning, and I think there is agreement to keep the current law on the outstanding issue of interpreting diagnostic studies and so forth. And I believe Miss Rowe has the mechanics of how we've agreed to do that.
Yes, I have that.
Robin, I'm sure that's okay if Steve says it. Yes?
We're good, and it was a good phone call.
Okay.
Yeah.
Next unresolved issue, or at least unresolved as of
last meeting.
Yeah. Okay. Next issue, Robin.
Well, that was the delegating medical acts under 14306, whether or not there would be any minimum requirement for clinical practice hours, and if so, what that number of hours would be.
So what is the difference, Robin?
So the difference is that the PAs would like for the law to authorize this, for PAs to be able to delegate to medical assistants, and then physicians in the collaboration agreement could authorize that or restrict it as they see fit. The Board of Physicians would like to put an hour threshold on that. And they have suggested 10,000 hours. And so that is the difference. We would not like an hour's threshold, and the board would.
What about a lower threshold? I'm sorry, Delegate Cullison. You are muted no longer.
Thank you,
Okay.
Mr. Chair. So Robin, I just want to be clear. The proposal is that the delegation authority or not would be included in the collaboration agreement. So ultimately, the physician is taking on the responsibility in that collaboration agreement. Is that what I'm hearing?
Yes.
Okay. Then it seems reasonable to me. There is a role for the physician to play in delegating or not that authority. Correct? Okay. Thank you. Thank you, Mr. Chair.
Mr. Wise, is that your understanding or is that acceptable? Or why is it not acceptable?
Delegate Colson's statement is correct. I think you're going to hear from the board. We tend to side with the board on this issue, but do not want it to stand in the way of the bill.
Matthew?
Sure. And just to clarify, because I think a lot of what was discussed at the prior meeting, patient history, interviews, things of that nature, I want to be clear that those are already duties that medical assistants can perform. There's nothing preventing a physician assistant from, directing a medical assistant to perform duties like that. This would be a fairly dramatic change from current law. I know that, much of this has been kind of broached as being consistent with current practice. It is not permitted under current law. It would be, when we're talking about delegation of medical acts, it's a fairly dramatic change. So, the board just wants to see that there's some experience provision in there, because the default would be that they would be allowed to do it immediately. It's not even specified.
Excuse me, would a number less than 10,000 be acceptable to the parties?
I think that we could, I think what makes the most sense to me is that whatever number we settle on for the not requiring an approval of advanced duties, whether it's the 10,000 that the board's proposed or the 7,000 that the physician assistants have proposed, I think it makes sense to be consistent from one to the other. We would have no problem with that. But, we do want to see some experience requirement for this delegation of duties.
Ken Kerr?
Thank you, Mr. Chairman. As sponsor of the bill, my suggestion is that we settle on the 7,000 hours.
We give a lot of weight to the sponsor. Robin?
So thank you so much. And we just want to flag, we think, having an hour's threshold is going to create some confusion in implementation. But we do appreciate being able to collaborate and work with, using the word collaborate, with the Board of Physicians and the sponsor and all the committee members on exploring this question.
So 7,000 would be acceptable? In quotes?
It is the will of the committee. Our preference is to not, but at this point, we just want a bill, and so it's the will of the committee.
Delegate Hutchinson?
I agree with Delegate Kerr, 7,000.
Is there consensus among the committee members on 7,000?
Agreed. Delegate
Agreed.
Woods.
Okay.
Agreed.
Yes.
So is there then consensus on, is that the end? Does that resolve everything,
Yes.
council? Okay.
That resolves that particular item.
Oh,
I have two more on my list.
okay.
There's the definition of exempt facility, and what is included in that.
Who wants
This
to
is
go
on
first?
the page after page 21.
Why don't you say it neutrally first, please?
I'm not
maybe-
sure what you mean by neutrally.
Well, oh, so there is no provision before us?
There is, I'm sorry. So this definition of exempt facility appears on the page after page 21 in your packet. And the question before you is, so right now in the consensus version, it's a hospital, an ambulatory surgical facility, or another practice setting listed on a hospital delineation of privileges document. I think there was perhaps some consensus last week on adding F2HCs and the PAs would like to add some additional items to that list. Additional entities.
Let me hear first from the PAs, Robin Elliott and then Jennifer Whitten.
So thank you. We appreciate that. I think generally everyone is fairly comfortable with FQHCs. We understand that there are questions about local health departments and school-based health centers. We'd be more than happy to work with the board and other stakeholders in the interim on figuring that out. So it doesn't have to be decided in this bill.
Very good. Does anyone else still need to speak on that issue now that it's been put off? Jennifer?
Thank you, Mr. Chairman and committee members. So I would just respectfully request that we also add urgent care centers to that list. We've had a lot of conversations about the inclusion of urgent care centers, and we've done some work around ensuring we've got the right access at those centers. So I don't think that that's been a problem in the discussion on the bill, but would ask for them to be included.
Is that acceptable? Yes or no? Matthew?
Yeah, I would, and very respectfully, I would resist adding urgent care centers. The main piece that we're looking at is whether there's whether there's regulation existing in the facility and whether there's a required credentialing process. While some urgent care centers may do that, and some may be within a hospital system, in which case they could qualify under the hospital delineation of privileges exemption. Unfortunately, urgent care centers are not regulated in the state of Maryland through OHCQ. There's no credentialing requirement for practitioners working there.
Mr. Wise?
Yeah, I think there's some confusion about what's being discussed. I think Ms. Whitten was proposing that urgent care centers be discussed over the summer along with the other potential items, which I'm more than willing to do. But I think what we're adding right now are federally qualified health centers, and everybody's agreed to that. So that would be the one addition to the bill. The other things, I think, we've agreed to discuss.
Summer study. Okay. Is that
That's fine.
acceptable?
Yes, but absolutely.
Sponsor and everyone. Okay. Is there anything else that needs to be resolved? Council?
The last item has previously been alluded to, and that's the delegation of advanced duties without prior approval or performance. I apologize. Delegation is not what they're doing anymore. The performance of advanced duties without prior approval from the board, and whether or not what that clinical practice experience hours level would be. The two numbers that have been put forth are 7,000 hours or 10,000 hours.
Mr. Wise?
I think that we had agreed anyway to make that the 7,000 hours, which makes it consistent with what was discussed earlier.
Robin?
We had also agreed to 7,000 hours.
Done. Done. Therefore, there are no remaining issues?
I don't have anything else on my list. Anybody else?
Robin? Oh, no, you took your hand down. Very good. Is there a motion on the bill as amended with some of these amendments having to be put on paper?
Second. So moved.
So
Second.
moved. All those in favor of the amendment say aye.
Aye.
All those opposed? On motion on the bill as amended?
Move the bill is amended.
Second.
Moved and seconded. All those in favor, please say aye.
Aye.
Anyone opposed, please raise your hand. It is unanimous. Okay, Lindsay, 1388. Labor and employment non-compete. Go ahead.
Sorry, this bill was also held last week. The bill expands the application of provisions of current law stating that a non-compete or conflict of interest provision in an employment contract is null and void under state law to an employment contract for an employee that's required to be licensed under the health occupations article or as a veterinary practitioner or veterinary technician. As introduced, the bill had a provision applying it retroactively to any employment contract entered into before the bill's October 1st, 2024 effective date. In the last meeting, there was a question about the retroactivity provision. I circulated an email we received from the Office of the Attorney General which essentially said that it would depend on the circumstances of the contract. Based on that email, the sponsor of the bill, Delegate Hill, who I don't see here, I'm not sure if she's on this call, submitted an amendment that I also circulated to everyone, striking that retroactivity provision and altering the bill's effective date to June 1st, 2024.
Is there discussion on the amendment?
Delegate Hill is here.
Oh,
Delegate Hutchinson.
Yeah.
Is Delegate Hill here?
yeah, she is here.
Okay. Delegate Hill, do you wish to speak to the amendment?
No, I
Your
think
amendment?
Lindsay summarized things well. I think it's good that that you all requested that information. Now we have it. I'd like us to, take the amendment and move forward and do what we can for the future.
Delegate Hutchinson.
Yeah, could I just get a clarification on the retroactive?
So the
So-
retroactive goes out. There would be no retroactive. In other words,
So, so if an existing agreement exists, it still is it's still in existence. This would only affect future.
no, I think there are a couple pieces to retroactive, as I understand it and discussed it with Lindsay. So if I've left and I'm under a non-compete, okay, then when the law goes into effect, that might not be enforceable. In other words, this bill's doesn't address that. If I have a non-compete and I'm still with the company, let me let Lindsay explain it. I'm walking through three different things, so let me let the attorney explain it.
Well, essentially, it's going to turn on the facts of any individual case of a person's employment contract and the circumstances under which they entered into that contract. So essentially, even a bill that doesn't ostensibly apply retroactively could still apply to a contract that was entered into before the bill's effective date, depending on the circumstances of that contract. In the letter, they gave this scenario where there was this sort of constant renewal of the contract. So it was like the contract had been renewed, in which case then it's renewed under the provisions. It would be renewed under the provisions of this law moving forward. So as I said, as so often, it depends. So basically where you'd be put is any employee who's wishing to terminate an employment contract that had this kind of provision in it would have to, argue their case based on the individual circumstances of their case and the circumstances of this law having been passed.
And I see Dr. Caniglia had something he wanted to add, if Mr. Chairman.
Certainly. Dr. Caniglia, thank you. You're muted. Now
Yes,
you're-
sorry, thank you. I appreciate the committee working on this. I think as the attorney just pointed out, if passed without this clause in it, it's just going to turn into every doctor and veterinarian having to go clog up the legal system and argue their point in court, when it seems like the intent of the committee is still to be able to apply it retroactively, just not actually to say it in the law. And getting back to the patient care issue, if doctors are still afraid of a non-compete being enforced against them, that is what leads them to not speak up when they see malpractice happening or when they see decisions that are being made in a hospital setting that directly adversely affect patient care. And so those patients are still going to suffer until all of these non-competes eventually expire within the state, maybe 15, 20 years down the road. Thank you.
Thank you, sir. And I would say this committee figures to be, I'm sure, would be sensitive to cases that are heard by the courts and how this statute is being interpreted, should it pass, and its effect. So we'll be back. So
Chair?
is there an amendment needed? Yes, the Hill Amendment. Do you wish to offer that now, please?
I'm not in the committee.
Oh,
member.
okay, fine. So the amendment.
I would
will-
move Delegate Hill.
Delegate
amendment.
Cullison, thank you.
Second.
Moved and seconded on the Hill Amendment. All those in favor, say aye.
Aye.
Opposed, no. Bill, as amended, is there a motion?
Move the
Move
bill.
the bill is amended.
Second.
Second. All those in favor say aye.
Aye.
Delegate Hill, do you really wish to speak?
Well, no, I just
Got the
wanted to,
votes.
yeah, I just wanted to point out that I know the constituent who brought the bill is very concerned about people who have been outside. But I think reading the letter, what's really clear from the letter is, although as Lindsay said, we're not clear going forward, it seems to me that what it's saying is if you have a non-compete now and you're still there, that will not hold. So it does make a difference for people who are currently in it. It's just that it doesn't go back and then validate a valid non-compete. If a person had a 2-year non-compete, they may have to finish that 2-year or go to court. But it does make a difference. They would not be having to, those contracts going forward and the contracts that are written that the person hasn't left. My understanding is that it invalidates that, but there may have to be some court cases. So I just want the committee to know that you are doing something. Something is happening with this. And what was clear from the AG's letter is that keeping that provision in there would put the whole entire bill at risk. Thank you.
Thank you. Bill as amended. All those in favor? Aye. All those opposed? Delegate Hutchinson, anyone else opposed? Okay. Council, I believe we are done with your two bills. Lindsay?
Yes, that's right.
Mr.
Fine.
Mr. Chair,
Okay.
I'd just like to share, I just still confused about the amendments of what happened. I just elected to go down right now. That may change when we go back to committee.
Okay, thank you, sir. Thank you. Okay, at 1:25, we now move back to the top of the list. House Bill 68, continuing care retirement communities. And if someone has their mic on, please mute yourself. Governing
This bill-
bodies, grievances, and entrance fees. Lisa.
This bill alters requirements related to termination of continuing care agreements and contractual entrance fee refunds by providers. It requires providers to submit reports to the Maryland Department of Aging regarding contractual entrance fee refunds, alters requirements for subscriber input, and requires the Department of Agency to collect information from providers regarding internal grievances. The amendments require providers to post the most recent disclosure statement on the provider's website. They require providers to hold quarterly meetings open to all subscribers. They require the last quarterly meeting of the year to include a summary of internal grievances. They retain current law for membership of provider governing bodies. They require the governing body to make determinations of whether a matter is confidential. They specify that the Department of Aging will collect information on grievances annually, specify the department will submit a report on grievances to the Finance and HGO committees, and retains current law on terminated continuing care agreements, but requires a provider to submit a specified written report to a subscriber whose unit has not been reoccupied within 9 months, and follow-up reports every 6 months until the unit is reoccupied.
And are there amendments to the bill?
I just described the amendment.
Sorry, I'm sorry. Is there discussion on the amendments? I see no raised hands. Is there a
Excuse
motion
me,
on-
Mr. Chair.
Yes. Delegate Lewis.
Thank you, Mr. Chair.
And then Delegate Whitehall, Holland.
Forgive my analog hand raise.
Go ahead.
Thank you. I just want to make sure that I understand how this bill has been amended, because I have constituents who are really concerned about residents and families of residents being included in, processes of grievance and decision-making and disposition of this contracts and all that. So can someone explain to me if the advocates from the side of families are satisfied with these amendments, please?
Mr. Shattuck or Ms. Braccato, whoever.
Yeah. Hi, thank you, Mr. Chair. thank you for that question, Delegate Lewis. I think, where the bill stands is as of after a lot of negotiation and discussion, and we see it as a first step towards addressing a lot of these longstanding concerns.
So the advocates are support the amendments.
Yes.
Okay, and as does, who represents the management, if you will? Is there anyone here? But Mr. Shattuck, okay. Allison Siborowski and Dana
Yeah.
Kaufman, please.
Yes, thank you, Mr. Chair. Yes, we've worked with the proponents and have found some areas where we agree, which are reflected in what Lisa shared. And we'll continue to work collaboratively with MACRA over the coming year.
I heard you say on the areas where we agree, so I knew this was not a done deal. For the future, that is. Dana, and then Aaron Greenfield.
For sake of time, we're fine with the amendments and we'll keep talking with the advocates over the interim. Thank you.
Terrific. Aaron?
Yeah, me too. Thank you.
You were well trained. Very good. All those in favor of the amendments?
Aye.
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 Bill is amended. Is there a motion?
Move the bill as amended.
Second.
Seconded. All those in favor of the bill as amended, please say aye.
Aye.
Is there anyone opposed? No. Very good. Thank you all for your working together there.
Wait,
one-
Delegate Riley.
Oh, okay. Riley and Morgan and Hutchinson, you wish to vote no? Okay. Council, have you recorded that?
Mhm.
Okay, we can move on then. Thank you. House Bill 464, Health Occupations Practice Audiology Definition.
This bill specifies that practice audiology means to use any means known in the science of audiology to evaluate, diagnose, manage, and treat auditory or vestibular conditions in the human ear, prescribe, order, sell, dispense, or fit hearing aids to an individual for the correction or relief of a condition for which hearing aids are worn, prescribe, order, sell, dispense, or externally fit a sound processor to an osseointegrated integrated device for the correction or relief of a condition, and prescribe, order, sell, dispense, or externally fit a sound processor. There are amendments that were distributed that clarify that the definition is limited to removal of serenum that does not require anesthesia. It's limited to ordering cultures and blood work related to conditions of the ear, and it's limited to ordering imaging related to conditions of the ear.
Okay. Who wants to discuss the first unresolved issue? Ms. Mercado. You're muted. You are muted. We still can't hear you.
Okay.
There we go.
Delegate Rosenberg and
That's me.
and
Yes.
committee and Delegate Martinez and others. So Dan and I represent the Maryland Society of Otolaryngology, and we have seen this bill as it was originally drafted has a dramatic change, and even with the amendments that have been offered, we opposed the bill. We did have the benefit of having a good meeting with the sponsor this morning. And the major objection is around the terms in the original bill that state that the audiologist can evaluate, diagnose, manage, and treat auditory or vestibular conditions in the human ear. We have stated that we think that language is very, very broad and request that it be narrower. in our meeting this morning, as we were discussing different terms, like using the term non-medically evaluate or triage, as we have offered in the past, the sponsor of the bill, Delegate Martinez, said, well, you know, there's these terms are used in the VA statute. And here I have a copy of it. And he was kind enough to make a copy and give it to us. And we looked at it and we said, well, from the onset, we've suggested that this language needed to be narrower. And the VA language is narrower. And if the subcommittee would consider the VA language, our client would not be opposed to the legislation. And because we were in discussions with Delegate Martinez and waiting to hear kind of where the proponents are, we did not yet, you know, I guess no request has been made to to draft an amendment because I think Delegate Martinez and the proponents of the bill were still having discussions, but.
Well, let's hear from them. Hold on.
Okay.
Let's hear from Delegate Martinez. We'll get back to you.
Thank
Delegate
you.
Martinez.
Thank you, Mr. Chair. So Barbara's correct. We did have a fantastic meeting this morning. I want to thank her and Dan for taking time to meet with me early this morning. I was able to share the language with the audiologists as well as their, support through Mr. Glenn. And, as of right now, we feel like what we have amended is a compromise and has been a compromise. And I see Dr. Alicia Spoor here as well, who could talk to why the VA language is not right for this particular bill and why we need to pass the bill as amended.
Dr. Spoor.
Thank you, Mr. Chairman. Thank you, Delegate Martinez. I appreciate allowing me to comment on the VA language. The VA language that we saw was proposed was pulled out of the description of what is an audiologist, not what is the scope of practice of audiology. And so when we go back and look at the VA handbook as it's updated for the scope of practice for audiology, you will see the words diagnose, management, and treat within the scope of practice of audiology. And they also clearly state that the scope of practice is based upon the National American Academy of Audiology and the American Speech Language Hearing Association, AAA and ASHA respectively, and their scope of practice, which uses the language evaluate, diagnose, manage, and treat as we have originally written in our legislation. So when we're looking at that, we want to make sure the statute isn't too broad, as Barbara Mercado mentioned. I appreciate that we just leave it wide open and reference AAA and ASHA, who could make changes at the organizational level without making changes through the state that would grossly expand the scope of practice of audiologists in the future. And so that's why we have come to the agreement of evaluate, diagnose, manage, and treat. Evaluate is already in the current statute. Diagnose is already in the COMAR regulations for an audiologist. And as you heard from Lisa Simpson, the ability to prescribe and order hearing aids was already passed last year and signed into law, which we believe also kind of ties into the fact of management and treatment. So I will stop there and happy to answer questions.
Gil Jen, briefly.
Thank you, Mr. Chairman. Yes, very briefly, Dr. Ford did an excellent job. One of the things we don't want to do is do unintended consequences. This would be the first statute in the United States that would adopt the VA language in an audiology statute. We think that's a mistake. Additionally, the concern of adding the practice of medicine, again, the back end of Delegate Martinez's bill has explicit language exempting surgery. 14101, the practice of medicine, is diagnose, healing, treatment, and surgery. We treat and we diagnose. And all the other statutes that we submitted in our testimony also include the word manage, and particularly what we are licensed for, and this will be my last comment, on the ACAE standard that the Board of Examiners, which licenses audiologists and have supported this bill as written, says that diagnosis and management of audiologists includes diagnose, triage, treat, manage auditory and vestibular balance conditions and diseases for patients. The problem with the VA amendment, it takes out vestibular and auditory, which has been in our statute for 20 years that we're trying to modernize. So I'll just stop there. I think it's a sort of a late entry, and I think after 5 meetings, we had reached consensus with our other amendments as well. So respectfully, we're going to have to oppose this amendment.
Is there any discussion from members of the committee?
If I can just also add, Mr. Chair, what we're doing with management, diagnose, and treat is in both the Colorado and Alabama practice for audiology as well. So we wouldn't be the first state in the nation to have this. This is just modernizing what we would like. And we also did some research on the non-medical with other states that had that in their statute. That hadn't been updated in over 20, 30 years. And so when we're trying to modernize these statutes to, align with what's happening in practice today, this language that we currently have, we feel it does that appropriately.
Okay. Ms. Healy Conway?
Yes, Steve Wise had to leave. On behalf of Meg Kai, we are still opposed to this bill with the proposed amendments, but we are willing to continue to work this out in the future.
Okay. I'm going to hold the bill and talk to some of my colleagues and see how we might, underline the might. You guys should keep talking, but let's see if we can be of any assistance. So for now, the bill is held.
Mr. Chair.
Yes.
I will say we've had over 5 meetings regarding this. I don't think there's a meeting limit, but I don't know how many more words can be said that I think we've met at a place in which we might be at an impasse. And so with the sake of time, I don't want to limit our ability to get this across the finish line to have another conversation where we're going to still be at an
There
impasse.
is time. There is time. You have my commitment.
Okay.
Because I said beforehand that there are bills that we might not get to. Delegate Bagnell.
Mr. Chair, would it be appropriate to move the amendments as described by our LA so that we can at least continue the discussion?
Okay, a good idea. Thank you.
I would like to move the amendments as described by Lisa.
Second.
Okay, is there any further discussion about those amendments or any questions from members of the subcommittee? Seeing none, all those in favor of the amendments, say aye.
Aye.
Anyone opposed? No one is opposed. Okay, we've accomplished that. We will continue our conversations amongst ourselves as members, and I hope that you will think that would be worthwhile for the parties, but we'll do our part. The next bill would be 1122, correct?
Yes.
Maryland Healthcare Commission nursing homes acquisitions.
As introduced, the bill requires a person at least 120 days before making a contractual arrangement for the acquisition of a nursing home to submit a request for acquisition to the Maryland Healthcare Commission and provide specified notice to the residents and staff of the nursing home. The executive director of the commission must review a completed request within 60 days and in consultation with the Secretary of Health may approve the acquisition with conditions, deny the acquisition, or refer the acquisition to the full commission for a final decision. There were amendments that were distributed that clarify when a provider is required to provide notice of a change of ownership or submit a request for approval of an acquisition. They require the executive director to complete a review of an acquisition request within 45 days and authorize the executive director to consult with the secretary's designee. They require the commission to make a final decision on an acquisition referred to it by the executive director within 60 days of receiving the request. Requires notices of final decisions and reports to be provided to the long-term care ombudsman, allows a person acquiring ownership to temporarily delicense beds for 3 years to reduce the number of rooms with more than 2 beds, and authorizes the commission to extend the 3 years for good cause shown. It clarifies the criteria the commission will consider when making a decision on approving an acquisition, and it provides that the regulations adopted by the commission will apply prospectively. And I think there are others here who could probably provide more detail if anyone needs it.
Dr. Steffen? Can you summarize? Are you there? You were. Ben, please.
Yes, I'm here. So
Thank
the bill as amended has the support of the Healthcare Commission. We believe that the modified bill does meet the needs of all the stakeholders. Most importantly, does provide greater transparency in the acquisition of nursing homes, both by purchasers from within the state and outside the state. It does provide a process for the review of applications that meets the request of the purchasers and sellers that it be done promptly, and gives the commission through the executive director the ability to make prompt decisions, but preserves the right of a purchaser or seller to appeal those decisions to the Healthcare Commission for final approval. It's been a long effort. I appreciate all of the stakeholders' participation. I think we, as of this morning, I think we had consensus that this was a piece of legislation that we are all proud of. And it does align interest of consumers, purchasers and sellers, as well as the regulators.
Thank you. Dr. Steffen says there is consensus. Is there anyone who wishes to dissent?
Move the
from that?
amendments.
Ms.
Second.
Ellis, sorry.
Second.
Ms. Ellis. You're
Sorry about that.
Start
My
again.
name is,
Okay.
no, thank you. I'm the State Long-Term Care Ombudsman. Thank you for getting my comments. I appreciate Ben Steffen's work on trying to get consensus. I would ask if, it may be too late, but if the definition of acquisition can match the CMS definition, which means 5%, it still says 25% in the bill. There's also, I appreciate the addition of sending the state ombudsman the final decision, but I wondered if the state I had asked in my amendments if that the state ombudsman be involved in the comments about the company acquiring acquisitions. That's on page 5 of the bill, because we go into the nursing homes more than anyone else. We regularly are mandated to go into nursing homes to visit residents, to address complaints, that sort of thing. And that there's something about, I think that when a change of ownership happens between family members, that should be public as well. It excludes that. We do have companies, large companies that change hands within families, and that should be publicly available to increase transparency. And then the last thing on page 2, there's a big bracketed section.
Did you participate in the discussions?
No, I was not invited. No.
Okay.
I submitted written testimony, but I wasn't included in the discussion. So I'm
Okay.
sorry about that. So, but, and then the last thing is on page 2, there's a big bracketed section that's omitted about giving the commission information from OHCQ, including quality ratings. I think that should be kept. So I appreciate you allowing me to speak. Thank you.
Anna Kaufman.
So on that last part about the brackets, the reason those brackets are there is because now the commission is the entity that can do the actual approval and disapproving. So that has actually been rewritten into the statute as opposed to just making findings and recommendations. So that's why those brackets had to be removed. I will also say that this is a product of a interim work group that met, I think, 5 or 6 times. Those issues were not part of the work group recommendations. We think that we've come very far in this, and we would ask that it be moved as is.
Ms. Locke, if I've got that right?
Yes, you do. Thank you.
Okay.
The Attorney General's office submitted an approval letter with amendments, and as amended, the bill did not address or include any of our recommended amendments which deal specifically with disclosure of all of the interests of owners that are interested in acquiring nursing homes, and specifically with private equity investments in nursing homes and all of the complex structures involved with those organizations. We believe that the bill should include language that would require disclosure of the private equity interests and related parties that are purchasing or interested in acquiring nursing homes.
Well, my inclination is to give you everyone another 24 hours, or until we meet again, whichever comes first. Well, when we meet again, to see if any of these issues can be resolved. But I want to make it clear, we do want to move, and we have every reason to believe we will move the bill forward. So we're going to hold it for now, but with that caveat. Thank you. HB 1327. Maryland Department of Health Body Altering Aesthetics Advisory Committee. Lisa.
This bill establishes the Body Altering Aesthetics Advisory Committee within the Maryland Department of Health. The advisory committee is chaired by the Secretary of Health or a designee and must meet at least twice each year. Member of the committee may not receive compensation, but is entitled to reimbursement under the standard state travel regulations. The advisory committee must submit a report to the governor and the General Assembly by December 1st, 2024. That's the interim report, and December 1st, 2025, the final report. The committee is required to study whether the current health occupation licensing and certification system adequately regulates the body altering aesthetic industry in the state, and whether it is in the best interest of the state to require some sort of national certification for the healthcare professionals that participate in the body altering aesthetic industry, or establish if it would be in the best interest of the state to establish a state regulatory entity to certify these healthcare professionals. There was an amendment that was distributed that adds the chair of the physical therapy board or the chair's designee to the advisory committee.
Is there discussion on the amendments? Is there a motion on the amendment?
Move the amendment.
Second.
So moved.
Second.
All those in favor of the amendment, say aye.
Aye.
All those opposed? Is there a motion on the bill as amended?
Move the bill.
Second.
Second.
All those in favor of the bill as amended, please say aye.
Aye.
All those opposed? None. Okay. I think we have 2 bills left. Is that correct, Lisa?
3.
3, appointment of the State Board of Examiners. I saw audiologists and I got, never mind.
Can we take actually the 2 massage therapy bills first?
Certainly. Yes, good sponsor. House Bill 1497. Council.
So House Bill 1497 alters the definition of practice massage therapy to include certain techniques. A former licensee seeking to reinstate a license must, in addition to other requirements, submit evidence of having completed a state and national criminal history records check. The State Board of Massage Therapy Examiners will require any applicant whose application the board is reviewing or licensee whose license the board is investigating to submit to an appropriate exam by the healthcare provider. that will be designated and paid for by the board if the board has reason to believe and objective evidence that the applicant or licensee may cause harm to individuals affected by the applicant's or licensee's practice of massage therapy. That's pretty much standard language for several of the other health occupations boards. There was a amendment distributed on this that strikes language related to authorizing cupping.
Is there discussion on the amendment?
Move the amendment.
So
Second.
moved
Second.
and seconded. All those in favor say aye.
Aye.
Aye. On the bill, is there a motion on the bill as amended?
Move the bill as amended.
All
Second.
those in favor of the bill as amended, say aye.
Aye.
Anyone opposed? No, unanimous. 1498. Lisa, 1498. State Board of Massage Therapy Examiners aiding or abetting unauthorized practice prohibition.
I'm just trying to get there.
I understand.
Okay.
I was
So
trying
this-
to fill in for you.
This bill prohibits an individual from aiding or abetting the unauthorized practice of massage therapy in the state. A violator is guilty of a felony and on conviction is subject to, for a first offense, a fine up to $5,000 or imprisonment for up to 1 year. And for a second offense, a fine up to $20,000 per day or imprisonment for up to 5 years. A violator must reimburse the State Board of Massage Therapy Examiners for the direct costs resulting from a prosecution. In addition to criminal penalties, the violator is subject to a civil fine of up to $10,000 as assessed by the board. There were no amendments.
Is there a motion on the bill?
Move the bill.
Second.
Moved and seconded. All those in favor say aye.
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 Anyone opposed? Thank you very much. House Bill 1476. Lisa, State Board of Cardiologists, Hearing Aid Dispensers, Speech Language Pathologists, and Music Therapists, appointment of members.
This bill specifies that the governor must appoint the audiologist member of the State Board of Examiners for audiologists, speech language pathologists, and music therapists with the advice of the Secretary of Health from a list submitted by the Maryland Academy of Audiology rather than the board. There are no amendments.
Is there a motion?
Move
Or is
the,
there still discussion needed on this bill? Nope. Seeing no amendments, is there a motion on the bill?
move the bill.
Second.
Moved
Second.
and second. All those in favor of House Bill 1476, say aye.
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 All those opposed? Okay. Delegate Cullison, it's all yours. We finished
Thank-
before 3 o'clock. And is there also a meeting of the Public Health Subcommittee?
Yes,
Member
Public
Bagnall,
Health Subcommittee will be meeting at 2 o'clock as well as the Insurance Subcommittee.
I'll be
Right.
joining you there. We are adjourned. We will be coming back tomorrow. Thank you all very much. That was a